Do you want to handle that case right now, Judge Najee Goodman? Mr. Bowditch has spoke to him.
Mr. Bowditch, are you ready on Goodman?
Well, Your Honor, I spoke with Mr. Goodman. Mr. Goodman asked me to tell you that the prosecutor in this case has no power of attorney over him. He's an Israelite. There's no grounds under the bar code this matter should be dismissed. I believe he may want to represent himself.
Before we even get into the courtroom audio, you need to understand what you're about to witness here, because this is not your average sovereign citizen meltdown. Today's defendant isn't just claiming the court lacks jurisdiction. He's invoking a blend of pseudo-history, misunderstood legal jargon, and identity-based arguments that have absolutely no grounding in American law. These Israelite, sovereign arguments are a rarer strain, but they follow the same playbook: deny authority, redefine words, and overwhelm the court with nonsense until someone either gives up or shuts it down. And that's where this case gets interesting, because this judge is not confused, not intimidated, and definitely not amused. As this hearing unfolds, pay close attention to how the defendant avoids simple yes or no questions, how every interruption escalates the situation, and how the court methodically brings him back to reality. This isn't just about bad legal arguments, it's about accountability, consequences, and what happens when ideology collides head-on with an actual courtroom. Stick around, because this only gets more chaotic.
You may ask for some clarification if you talk to Mr. Goodman, but that's what he told me to tell you.
Thank you. Mr. Goodman, are you requesting that you represent yourself on this matter? You're muted, Mr. Goodman.
What I'm saying is, nobody has power of attorney law over me through the barcode. I'm the beneficiary. My name is not those capital letters, so I'm an Israelite from the 12 tribes. So what I'm saying is I'm representing myself. That's all that needs to be said, because that's what the law is. I got common law jurisdiction. It's a non-violent crime. So I push for it to be dismissed under the barcode.
Well, it's not going to be dismissed today. So simple question. Are you representing yourself from this point forward? Yes or no?
Yes, I'm counseling myself.
All right. Mr. Bowditch, you're out. Thank you.
Thank you, Your Honor.
This is the first critical moment, because right here the defendant signals exactly how this hearing is going to go. Notice how instead of answering the court's very simple question, "Are you representing yourself?" he launches into a rehearsed script about power of attorney, barcodes, and identity. This is a classic sovereign citizen tactic: avoid clarity at all costs. Courts operate on precision. Sovereign rhetoric operates on confusion. When a judge asks a binary question and gets a paragraph of nonsense in response, that's a red flag every time. And here's the key thing viewers should understand: none of these arguments are new, none of them are clever, and none of them have ever worked. Courts across the country have rejected these exact claims for decades. So when the judge presses for a yes or no, that's not impatience, that's the court establishing a clear record before this spirals further.
I said, are you planning on filing a motion, or would you like to set this case for trial?
I'm planning on filing a motion to dismissal because there's no grounds or no standing over my case, because nobody has power of attorney law to hear me, to even take this process even further. You got to prove that first. You got to prove that you got power of attorney law over me to hear this matter.
Okay,
I'm an Israelite.
You're saying, but you don't know what you're talking about.
I do know what I'm talking about. You don't have power of attorney law. The prosecutor don't have power of attorney law. You don't have power of attorney law. It's under the barcode.
Mr. Goodman, please do not interrupt me. I'm trying to be polite.
Okay, it's under the barcode, though. This is what you signed up to do. You're a public servant. So
Right, unless you are a price on a can of beans, we don't need a barcode.
Watch how quickly the attorney steps away here, because this is an underrated moment. When defense counsel bows out this cleanly, it's not abandonment, it's self-preservation. Lawyers are ethically prohibited from advancing arguments they know are frivolous, and sovereign citizen ideology lives entirely in that category. The attorney understands that once the defendant insists on representing himself, the responsibility and the consequences shift entirely onto him. This is also where the judge's patience becomes strategic. By allowing self-representation, the court eliminates future claims of ineffective counsel or misunderstanding. In other words, the judge is locking the record down tight. If you've ever wondered why judges let people talk themselves into disaster, this is why. The court isn't being careless, it's being meticulous.
Yes, I am. I'm a human being. I'm not a deity. I'm a human being. I'm a living man. I'm a living being. I'm not no cargo. I'm not none of that. It's under the barcode. This is the real law.
come
You have
here.
no standing or no ground.
Mr. Goodman, I'm going to give you a date for your motion.
I'm
to
only
be
here to
heard.
threaten cohesion.
Pardon me?
I want all my rights intact to me at all times. Do you agree?
I can't understand what you're saying. I think you're too close to your mic.
I want all my rights intact to me at all times. Do you agree?
I can't understand you, so no, I don't agree. I hear you're
Okay,
something
well,
all the time, but I don't know what you're saying.
intact to me at all times. I want all my rights intact to me at all times.
This exchange is where the hearing truly derails. The defendant is no longer responding to the court, he's performing. Every buzzword comes out: beneficiary, capital letters, common law, nonviolent crime, barcodes. None of it connects logically, and none of it addresses the court's authority. Judges don't need philosophical agreement from defendants, they need compliance with procedure. When the judge cuts through the noise and repeats the question, that's not hostility, that's courtroom discipline. And notice how the defendant finally says, yeah, not clearly, not confidently, but reluctantly. That hesitation matters. It shows he understands the risk but is committed to the performance anyway. Ask yourself, if your freedom was on the line, would you gamble it on internet legal theories?
All right, I can't understand you. All right,
Okay.
Are you still living on border? Are you still living on border? Mr. Goodman, are you still living on border?
Ashley, keep yourself muted, please. Your child keeps crying. Thank you.
No, I live somewhere else. I moved.
All right, can you give me that address, please?
I stay at hotel rooms from time to time because I don't have no house right now. So I've been staying in a hotel room.
Geographically, where are you at today?
Detroit, Michigan.
All right. So my next pretrial date is when, Heather?
It is March 8th.
All right. So, Mr. Goodman, I'm going to give you a date on March 8th to file a motion. You file a motion, we'll hear it on March 8th. That's going to be in person.
Motion for dismissal?
Whatever you want to file a motion. You said you wanted to file a motion. So I'm giving you a hearing date for your motion.
What time?
We'll schedule that at 10 a.m. and this is going to be live. No Zoom.
All right.
I'm having trouble
All right. I
with
want
the audio.
all my rights intact to me at all times.
At this point, the judge draws a hard line, and this is exactly what effective judicial control looks like. The interruptions stop. The nonsense gets called out. And most importantly, the judge refuses to argue. Courts do not debate jurisdiction with defendants, they assert it. When the judge tells him, I don't have to prove a damn thing to you, that's not emotional, it's legally accurate. Jurisdiction is established by law, not by consent. This moment is critical because it signals to the defendant that intimidation, confusion, and volume won't work here. From here on out, every outburst only damages his credibility further. And viewers should note, judges remember this behavior later, especially when bond and compliance come into play.
I just want all my rights intact to me at all times. And everybody just got to prove that they got power of attorney law.
You got to slow down because you're talking so fast I can't understand you. I keep hearing all time, but that's all I'm getting.
Okay, what I'm saying is for the dismissal, I'm about to put it in today. You got to prove that you got power of attorney law over me. I'm going to have to sue the courthouse for 100-fold.
Mr. Goodman, I don't have to prove a damn thing to you, sir. If you're here on the
You got to prove
listen to your motion.
you got to
If you're
prove
not
that you
here on
got
the
power of
eighth,
attorney law over me. You don't have power. I don't care what you're talking about.
Attorney over you, Mr. Goodman. Listen
Yes,
to
you do. You need power of attorney law to talk to me. You ain't got no ground. You ain't no standing. You ain't got no ground to understand. I got the affidavit of truth right here. I got authenticate birth certificate. I got a letter of intent over here right now. I broke all my contracts with the government. I'm not those capital letters. I'm with the 12 tribes of Israel. My name is Israel. I'm an Israelite. I'm with the 12 tribes of Israel. You don't got no power of attorney law over me. I'll push it for dismissal. I'm suing your courthouse for 100-fold.
And here come the consequences. Threatening lawsuits, invoking tribes, waiving paperwork, none of it helps. In fact, it accelerates the collapse. Judges have an extraordinary memory for behavior like this, and it absolutely influences future rulings. When the judge orders him to appear in person, that's not optional, it's a test. And predictably, he fails it. This is where ideology meets reality. Courts don't chase people who refuse to recognize authority, they issue warrants. And when that happens, the conversation shifts from theories to handcuffs. This entire sequence is a masterclass in how not to conduct yourself in court. Every word spoken here tightens the net.
422.
Try it again, counsel, I'm sorry.
Good morning, Your Honor. Patricia Manning for the people, P84088.
All right. And Mr. Goodman, can you hear us okay?
Yes, sir.
All right. And Ms. Murphy, what are we doing on these files?
Judge, it's my understanding that Mr. Goodman has an appointment at the Forensic Center on January 31st. As Your Honor knows, he has pending cases in Frank Murphy. He went before Judge Michael Callahan yesterday. He was, his bond was reinstated with a tether. I believe Your Honor has put a 250, 10% bond on Mr. Goodman. You know, Your Honor, that I'm going to ask you to reduce that bond to something affordable.
All right, so I've got two files. One file's got that 250, 10% with a GPS tether. That would be the February 5, 2022 incident date. And then the other file, which is the misdemeanor file from May 10, 2019, he's just on a personal on that one with a GPS tether.
Right, and you know, Your Honor, that I don't represent him on the DV.
Right, right. But he finally does have a date for a forensic exam?
Yes, Judge.
Okay, all right. So you just want to adjourn the PCC?
Yes, Judge. And ask for a reduction in bond.
Thank you. And Mr. Goodman, have you talked to an attorney on the domestic violence case, or are you representing yourself on that one?
I have nobody to represent me. I think it was Langford or something was supposed to be my attorney. I'm not sure how it went south.
Okay. All right, counsel, go ahead and make your bond argument. But before you do, just so we're all on the same page, my notes say it's $25,000, 10%, no contact with complaining victim, and GPS tether. Is that your understanding?
So, Judge, I thought it was 250,000, 10%, 25,000.
I don't know what I just said, but
Oh.
my file says 250. Well, yeah, 250,000, 10%. Correct.
So, Judge, I mean, obviously that's unaffordable. Mr. Goodman is not a man of means.
Now we're in damage control mode, and the tone has completely changed. Gone is the bravado. Gone is the sovereign language. Now we're hearing about bonds, finances, transportation issues, and family responsibilities. And this is where patterns matter. Judges don't rule in isolation, they rule based on history. Missed court dates, non-compliance, and defiance all stack up. Even when both sides agree on a bond reduction, the judge isn't required to follow it. Judicial discretion exists for cases exactly like this. And notice how calm and controlled the judge is here. This isn't personal. It's procedural. Reliability matters. Compliance matters. And Mr. Goodman has demonstrated neither.
And his significant other just acquired new housing, Your Honor. They have a baby. Mr. Goodman needs to be there to assist with childcare responsibilities because both of them were working before Mr. Goodman was taken into custody. I know we've had some issues, Your Honor, with appearing in court. Mr. Goodman has had transportation issues with respect to getting to the forensic center, and that was his issue, Judge. The tether violation was simply a malfunction of equipment. So I would ask Your Honor to, and since they do not have means, Your Honor, I would ask Your Honor to reduce I'm asking Your Honor for a personal with the tether.
Response. And counsel, you don't have to jump up to talk to me. I know it's instinctive, but it's okay if you don't.
Thank you, Your Honor. It is instinctive. Your Honor, in this case, he is before us for a misdemeanor DV. I understand he does have some pending felonies. I understand he's on a GPS tether for the felonies. I believe at this time, the most important thing is that he remain on, or that if he is released, he remains on a GPS tether. So in this case, I would not object to a personal bond.
All right. Ms. Murphy, unfortunately, this is one of those situations where I don't care what the parties think, because I've got a long history. This building's got a long history with Mr. Goodman not showing up in court. So I set the bond for that reason. I'm keeping the bond as it is for that reason.
This case ends exactly how it should. The judge keeps the bond in place, not out of spite, but out of experience. Courts operate on trust, and when a defendant repeatedly demonstrates that they won't show up, won't follow orders, and won't even acknowledge the court's authority, that trust is gone. The key takeaway here is simple: beliefs don't override law, and ideology doesn't shield you from consequences. Sovereign arguments don't confuse courts, they exhaust them. And exhaustion leads to stricter rulings, not leniency. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Your engagement keeps this channel going, and we'll see you in the next one.